On March 7th, 2020, 23-year-old Keelin Hawkins was arrested in Harris County for driving while intoxicated and released the same day on a general order bond under Local Rule 9, which, except for certain carve-out categories, requires that most misdemeanor arrestees be granted an unsecured personal bond and promptly released without a judge's approval, meaning no upfront payment or separate bond hearing is needed. This system, unique to Harris County, was created by a November 21st, 2019 consent decree stemming from the 2016 class action lawsuit O'Donnell v. Harris County, which challenged the constitutionality of the county's previous misdemeanor bail practices. After Hawkins' release, her arraignment was set for March 13, 2025, before Judge David Fletcher, who would determine probable cause for the DWI charge and revisit bail conditions. Although her attorney record was Greg Holton, the arraignment was handled by his colleague Aaron White.
Good morning, Ms. Hawkins. Good morning. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
She had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. Ma'am, you're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After finding probable cause for the DWI charge, Judge Fleer imposed bond conditions ordering Ms. Hawkins not to consume alcohol and not to drive, even though the prosecution had only requested installation of an ignition interlock device IID, a breathalyzer that prevents a vehicle from starting if alcohol is detected. Under Article 17.441 of the Texas Code of Criminal Procedure, judges must require an IID for repeat DWI or aggravated cases. But because Hawkins was a first-time defendant, that mandate did not apply. Nevertheless, Article 17.40 grants judges broad discretion to impose any reasonable bond condition related to community safety. And while bond terms cannot serve as pre-conviction punishment, appellate courts review them under an abuse of discretion standard, upholding decisions within the zone of reasonable disagreement. Given allegations that Hawkins drove while intoxicated and had an open container in her vehicle, a reviewing court would likely find Judge Fletcher's alcohol and driving restrictions reasonably related to public safety and therefore not an abuse of discretion.
Understood.
We can approach at a later date, but I'm
concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting an interlock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. one would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously.
Later date. I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue, I mean.
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know, but it's something that I've seen more and more, you know, where there's alcohol in the car, and I would presume that you would know, especially at this age, that, you know.
Well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
Mr. White argued for limited driving privileges so Ms. Hawkins could travel to and from work. But Judge Fleer maintained a zero driving bond condition for the time being, emphasizing that bond restrictions on driving are distinct from a driver's license status under Texas's administrative license revocation process. Because her blood test results were not yet available, her license was likely not administratively suspended at that point. Yet under Article 17.40 of the Texas Code of Criminal Procedure, Judge Fletcher had the authority to prohibit driving altogether or to allow only work-related travel. If Hawkins's blood results later showed a BAC of 0.08 or higher, the Department of Public Safety would be required under Section 524.012 of the Texas Transportation Code to suspend her license. And even if the judge later eased the bond condition, she still could not lawfully drive without obtaining an occupational driver's license under Section 521.242, which permits limited driving for work, school, or essential household duties despite an administrative suspension.
And if that takes 90 days to get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates, come back and, you know.
And this is for Craig's purposes, so I can convey this to Craig. What's proactivity to the court?
Just be creative.
Okay.
Be creative. And, you know, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously, you know? I'm not asking for much. And once we know that there's appreciation, then let's talk again.
On April 8, 2025, Ms. Hawkins' attorney requested a hearing to review her bond conditions. And on April 10, 2025, she made her second appearance before Judge Fletcher, this time accompanied by her defense counsel of record, Greg Holton.
How's it going?
Oh, good. Thank you.
How has it been? Not tough, isn't it?
Yeah.
Sucks. Living in a city as big as Houston without the ability to drive blows. You know, and the only thing that I'm trying to get to you is to understand that it's a privilege. It's not a right. You know, every single day on our streets, someone is dying from some kind of alcohol-related collision. That's what we're trying to impart to you here, to take it seriously. It's not a joke, you know, and the last thing I want is for something like that to happen here. You understand? All right. I'll take off the restriction. Okay. What does she have now? I want to make sure that she has an interlock for now, just for a limited time.
Judge, if I could speak to that briefly,
Sure.
just to reassure the court that she fully understands the court position. I had her research and write an essay on alcohol-related accidents and fatalities. We can turn that in and take a decision-making course. Her case is a stop for expired registration, no accident. You got the blood this morning, it's a 1-3. She has no criminal history. So I would ask the court that to use this research she's done in the 28 days without driving at all to understand that she gets it. And if we can not have the interlock, as would have been if she didn't have an open container, that we proceed further and let us do the work of getting the discovery forward.
Okay.
I can turn both those in.
I want you to know, I will act to your lawyer, but if I find that you're using alcohol, I'm going to blow a gasket. I'm really just going to lose it. Just don't. That's all I'm asking you to do. Do you understand?
Yes.
Okay. I'll take a look at this. I'm going to acquiesce to you.
Thank you, Judge.
Just don't. Life is too short to spend the next month in a 6x9 box.
Mr. Holton informed Judge Fleer that Ms. Hawkins' blood test showed a BAC of 0.13, exceeding the 0.08 legal limit. Yet Judge Fleer agreed to remove the no driving condition from her bond and, at Mr. Holton's request, declined to require an ignition interlock device because her BAC was over the legal limit. Her license was likely subject to administrative suspension, meaning she could not lawfully drive without either contesting suspension or obtaining an occupational license, though that separate process was not addressed in this hearing. As of this writing, Ms. Hawkins' DWI charge remains pending. This episode highlights the broad discretion Texas judges have to set and later adjust bond conditions aimed at community safety, initially barring Hawkins from driving and consuming alcohol, even though the state had only sought an interlock device, and later lifting those restrictions once more information was available. While some may view the original limits as overly harsh given the early stage of the case, others see them as prudent, temporary safeguards that judges are expected to revisit as facts develop, illustrating how bond terms can evolve while a case moves forward.